Good afternoon, good afternoon, good afternoon again, everyone. Welcome to another episode of Spilling Tea. I'm your host, Tiffany Daniels. We are going back to that horrible world known as the JRC, but before we do, the usual disclaimers. If you are unfamiliar with the Stop the Shocks campaign or the campaign against the troubled teen industry, you're going to find all the pertinent links right there in the description box. Please, in particular, take note of the article written by NeuroClastic, a small non for profit started by autistics for autistics. They interviewed over 900 ABA professionals in regards to the JRC's so called behavior modification program. The Judge Rotenberg Educational Center doesn't want you to read that article so much. They've threatened NeuroClastic with a defamation lawsuit if they did not remove it from the website. NeuroClastic has refused, so you know the drill. Please read the article, share it on all your social media. Also included in there is NeuroClastic's public statement regards to the defamation lawsuit threat, as well as a link to their GoFundMe. We are crowdfunding, just in case the JRC sees through with their threat. Trigger warning 1. Excuse me, folks. When we discuss places like the Judge Rotenberg Educational Center or Agape Boarding School for Boys, you're going to hear vivid descriptions of and catch clips of surveillance footage of people with mental health issues and disabled people being tortured and abused. If you got young children present, folks, please go ahead and utilize those headphones. This channel is marked not for kids for a reason. We use profanity on occasion and speak on dark subjects. If your child is 16 and younger and they're watching this, very obviously parental supervision is advised, all right? All right, so where we left off. Now, this is going into a little bit of something I've already brought up, the fact that we've gone over and over and over again to try to get the consent decree of 1986 overturned and have literally not been able to get it done to this day. So let's get into it, shall we? The Bristol County, Massachusetts Probate and Family Court considered whether a consent decree should be vacated based on significant changes in the fact or law. In particular, whether professional consensus is that the JRC's GED does not now conform to the accepted standard of care for treating individuals with intellectual and developmental disabilities. For any state, that includes mine. I live in a red state. The evangelicals are the powerhouse here. Okay? This is not a progressive state. My state does not accept this as a standard for care. If you are from Massachusetts, a so called liberal progressive state, and my red, made up of hillbillies in evangelical states is beating you in regards to better treatment for people with disabilities, you should be really looking into what your state is getting up to, is all I'm saying. Because we shouldn't be beating you when it comes to the care of our folks with disabilities. Okay? We really shouldn't. And veterans. Yeah, let's not even get into that. If we're beating you, you should really assess what your state is actually getting up to, okay? Just saying is all. The court ultimately determined that no significant change in consensus warranted vacating the consent decree. The evidence at the hearing did not establish that there is a professional consensus with respect to whether level 3 aversive treatment conforms to accepted standard of care. This is what blows my mind about the Massachusetts courts. It's like they got a massive blind side to over the last 40 years in regards to the progress of medicine. Okay? You've got these people consistently saying, but no, it still meets standard of care. Where? Auschwitz? You know? That's why so many advocates who have fought for years, me being one of them, that there should be a federal consensus in regards to care for people with developmental disabilities should be established, because you got states like this that will turn a willing blind eye to what their professionals get up to in regards to medicine. A federal mandate in regards to what is accepted as standard of care would rip away that. You see what I'm meaning, right? How you can sit there, even as a judge with no medical background, how you can sit there and look at all the progress in regards to medicine over the last 40 years for people with developmental disabilities, look at all of that, and still say that adversive care is still 100% necessary, the very least says you need to be removed from the bench immediately. Bare minimum that you are never allowed to make any kind of decision from a seat of power in regards to anybody's treatment and care ever again. I wouldn't put you in charge of a snail. Just saying. The professional consensus regarding the accepted care of and such ESDs is not an issue in this ban. Rather, to ban a device under Section 516 of the FD&C Act, FDA must determine the device presents an unreasonable and a substantial risk of illness or injury, which we all did, beyond the shadow of a doubt. Okay? If surveillance video footage of a young boy screaming and begging for his life, ER documents documenting his second and third degree burns and his month of catatonia, the second and third degree reports from other ERs from the other students, the witness testimonies, and the surveillance footage to back it up does not convince you that this absolutely does fall into unreasonable and substantial risk of illness and injury, then I don't know what will. As explained in the proposed rule, in making this determination, the FDA analyzes whether the risks the device poses to individuals are important, material, or significant in relation to its benefits to the public health. And the FDA compares those risks and benefits to the risks and benefits posed by alternative treatments being used in current medical practice. I want to underline that for you. Current medical practice. Any other state, literally any other state, even my backwards, hillbilly, podunk, red, MAGA worshiping state, this does not fall within current medical practice. Think on that. We're going to close on that. We don't get very many views on this channel. The few that we do get do tend to get removed from time to time. So please don't forget to hit that like button, hit subscribe, and don't forget to hit the comments. I do appreciate your time. And as always, folks, we here at Spilling Tea hope you have a good one. I'll see you in a second.